shortly, in response to the confusion caused by the now famous case of the murder suspect Paul Hookway and police bail. The High Court upheld a district judge's ruling that time on police bail could count towards the 4-day limit of pre-charge detention. Now, it's quite complicated, this, but under the Police and Criminal Evidence Act of 1984, it's been standard practice for suspects to be questioned, released in police bail, and for the police, and indeed the prosecuting authorities, to assume that they could be questioned again if the 4-day limit, 96 hours, had not been reached first time round. The new court ruling says that is what the Act allows, and that once the 4 days begin to run, when the first questioning starts, it can't be stopped and started subsequently. Now, in yesterday's programme, the eminent legal scholar Michael Zander, QC of the London School of Economics, said the government was quite right to plan legislation which would in effect overturn that High Court ruling. He didn't agree with the judge either.
In my view, he's clearly wrong, and I think on appeal it would be held to be wrong if it ever gets to the point of an appeal. I'm hoping that the Home Secretary will intervene with urgent legislation because it's a situation that needs to be corrected. The only justification for the ruling is interpretation of the Act, which makes no sense. And if a literal interpretation makes no sense and it flies in the face of 25 years of experience, practice and reasonable interpretation, then it's in my judgment, it's wrong.
Michael Zander, QC. Well, Joseph Kotrie Monson speaks for Kotrie Monson Solicitors, who act for Paul Hookway. Good morning.
Good morning.
Why shouldn't the government act to try to clear up what is clearly confusion? I mean, wherever you stand on this, there is confusion.
Probably one of the biggest untruths that's been told about this situation, both in the press and by commentators from the police and also the Home Secretary, is that there is confusion. There is no confusion. The only confusion lies in how it is that over a period of 25 years, but not for the whole of those 25 years, a situation has evolved in which the police have begun to abuse the situation with regard to the bail time limits, so that they can actually keep people on bail for very long periods of time without new evidence. In fact, PACE is in the Police and Criminal Evidence Act 1984, which was brought in to give the police sweeping powers of detention and also sweeping powers of investigation, had built into it certain checks, such as the right to a solicitor, the right to a 4-day limit on bail, and it also says you can re-interview, you can re-arrest if there's more evidence.
If there's new... That's the key thing. You can bring them back, but there needs to be new evidence.
Of course.
Now, where in the Act does it say absolutely precisely that the minute questioning begins, pre-charge questioning, the 4 days has to continue uninterrupted?
It talks about the beginning of a clock. The fact that it doesn't mention anything else doesn't mean that there's confusion. In fact, the fact that it actually makes reference in a separate section to the situations in which somebody can be re-detained, well, it begs the obvious question. And we've heard the learned commentator refer to the fact that, well, this doesn't make any sense at all. Of course it makes sense.
Well, what you're suggesting is that the practice has become that people are taken back once the clock has started ticking, and it sort of gets added on to the 96 hours. And the key thing is they've been taken back without any new evidence being shown to exist.
That's quite right.
That's the key.
And what is actually promoted is slow CPS decisions, and of course the CPS have faced massive cuts, as have the police, so the investigation is not taking place in the proper way within the 4-day limit. Suspects are getting effectively shaken down at the outset rather than being properly interviewed on the basis of evidence. Let's bear something in mind. When somebody's arrested, they're not even supposed to be arrested under PACE until there's reasonable suspicion that they've committed the offence.
Just so that people know it's the Police and Criminal Evidence Act.
Either charge or let them go. This is not about murderers running the streets. Bear in mind, and this is something that has been consistently misrepresented over the past few days, bear in mind that this is people who the police are already saying they want to release on bail. The only difference is they want to be able to interview them ad nauseam over a period of years.
So to be absolutely clear, you are saying that the assertion that all sorts of, as usual, you get the list, murderers, rapists and armed robbers will be walking free as a consequence of this ruling is simply not true.
Well, it's absolutely not true. The reality is this these provisions were brought in place in the first place to make sure that if you're going to give police powers, then they do their job properly.
But do you believe that it is right that if, and let's just be absolutely clear about this, that if the police have questioned somebody for a period within the 4-day thing, and then they say, OK, on bail, and then something new comes up, they should be able to bring them back.
They already can, and pace in
I'm just making absolutely clear that you are not arguing with that power on the part of the police.
Certainly not.
So if there is new evidence, and, you know, courts in the end could decide whether it counts as new evidence or not, but if there is new information, then this ruling, in your judgment anyway, would not stop the police continuing questions in excess of the 4 days.
Looking at the original judgment, my colleague John here at the magistrate's bail hearing, originally at Salford Magistrates with Judge Feinstein, actually was making no objections at the beginning because he'd been assured by the prosecution in advance, or the police in advance, that there was new evidence. It only transpired in the course of the hearing that, in fact, there was no new evidence, and it was the judge who then raised the point.
But if there had been new evidence, there wouldn't have been a problem.
Of course, and it was on that basis originally we weren't even objecting.
Joseph Kotrie Monson of Mary Monson Solicitors on a story which will no doubt run and run. Thank you very much for joining us.
Thank you very much.
18 minutes to 9.